Welcome back to Court TV Live. I'm Ted Rollins outside the courthouse in Santa Fe, New Mexico, covering the Alec Baldwin case. But we want to switch gears momentarily here for some breaking news out of New England in the state of Massachusetts in the case of Karen Reed, the one we just finished up here on Court TV. The defense has filed a motion asking for 2 of the top charges against Karen Reed to be thrown out. And the reason they are asking it in this motion that they filed is because it has come to their attention that the jury had a firm 12-0 agreement that Reed was not guilty of 2 of the 3 charges against her, including that top charge of second-degree murder. According to Alan Jackson and David Yannetti, the lawyers, of course, representing Karen Reed, who filed this motion, they say that jurors got a hold of them after hearing reports about the supposed juror split. We've heard all kinds of things. If you've been on social media, people are saying, oh, it was, 6-6, or it was this, that. They're saying that jurors reached out to them and that the jury had unanimous verdicts of 12-0 on the top 2 charges. But apparently, what I'm reading here is they didn't put it together that they could have come back with those verdicts and said not guilty, and hung on that 3rd count. Let's bring in Jessica Ehrlich to discuss this. This is interesting, Jessica, because, we got the jury coming into the courtroom saying we are undecided. We can't come to a unanimous decision if this is true. Does the defense have a solid motion here to basically dismiss these charges? Because if indeed the jury was in agreement 12-0, they effectively came to a verdict on those top 2 charges.
Yes, I'm dying to get my hands on their motion because I would really like to see, from a legal analysis standpoint, if there are precedents in the state of Massachusetts that they're able to cite to in this matter. It's certainly from a public policy standpoint, we know that for all courts across the country, you always want to have, especially after a lengthy trial like this, and it's been to the jury, it behooves everyone, and it is sort of the public policy standpoint, that you want the jury to at least come back on 1 or 2 of the issues to avoid a mistrial. You really want to do everything you can to avoid the situation that we had here when they had a hung jury. So I definitely think from that standpoint, it's a very strong argument to make. The question is, in terms of Massachusetts, will the judge be able to call the jury back and feel that they're able to take this vote given everything that's happened since they were dismissed? So it will be very interesting to see. Definitely quite a turn of events here. We've been following this for a long time, as you know, and it is fascinating, and actually does not surprise me at all that the jury did have very strong opinions about those first 2. And you and I were talking when remember, there were so many issues with the jury instructions in this case that we knew that something was going to happen for sure. This was just very confusing for the jury. They had to redo the forms. So really, I'm not surprised that the jury came back on this. And it's very interesting that the jury actually reached out to the defense on this. I'm also curious as to how that transpired and what was going on there, that conversation was had.
And there has been so much misinformation because of the interest levels and the different bloggers that have jumped into this full force. It'd be, in terms of a remedy here, if the court really wants to find out, you don't just go by what the defense says, obviously, and you can't really just go by with what 1, 2, 3, or 4 of the jurors told the defense. Great, juror number 4 believes that it was 12-0. Don't you have to? Doesn't the court have to do a full investigation and contact all 12 of those sitting jurors to validate this claim from the defense, and then make a decision after establishing that this is in fact true?
Well, it'll be interesting to see how they, wrote their argument. I think certainly the judge would speak with the foreman, because really the foreman is supposed to be the spokesperson for the entire jury. So if the judge speaks to the foreman, if they even go that far, I mean, I don't know that it's really a matter of saying, is what the defense saying true? It's also a procedural thing. Can they even bring the jury back after they've been dismissed? Would this even be allowed from a just, jurisprudence, procedural Massachusetts law standpoint, to even whether the judge would be able to interact with the jurors on that matter, whether the court would. I mean, this is a very unusual situation, but I would say definitely they would start with the foreman, because the foreman is supposed to be the spokesperson of the entire jury body. They were elected by the jury, and they should be able to sort of speak to that. Now, I don't know whether in the motion the defense spoke to the foreman, and the foreman was the person who said, we had a unanimous decision on the first 2 counts, but could not go further, and didn't realize and didn't understand that that was possible for us to make a decision on. Because also there should be notes and everything kept by the foreman as to what actually transpired. It's just a very, very unusual and difficult situation. I mean, I can see why, from a public policy standpoint, it is what you want to avoid, having to do this entire enormous trial over again on all counts. But I mean, I'm dying to read.
But was it really a verdict? If they told the judge that they could not come to a verdict, was it a verdict? They may, if what they're saying is true, if what the defense, what they got from these jurors is true, that they all agreed 12-0, all right, definitely not murder 2, definitely not intoxicated leaving the scene of the accident, then they should have put that down on the verdict form, and that those were verdicts. Absolutely. Correct? And that's a mistake possibly from this jury. But how do you remedy that?
I mean, I think that is the ultimate question. And it's certainly going to be a matter of law and precedent. I'm not sure that there's a lot of precedent in Massachusetts that I'm aware of that would actually give the judge a lot of room here in terms of where to go. I mean, I know even with some of the issues with the form, it was unlikely that they were going to change the form. Then she reviewed the various arguments and came back. So this is really sort of one of those arguments. Certainly, even if the judge says no, the jury was dismissed, this is something that, they can try to bring up, I think, in their appeals and in everything else, that this was, a tainted trial from the get-go, and especially given the fact that the jury was confused as to what their instructions were. We know that there was confusion around what the form was, and that led to the situation that they were in, and therefore it should be, tossed out. So I mean, this is going to be a really interesting, I'm dying to hear the arguments on this.
Yeah, and just reading parts of this motion, it's not clear that they have definitive evidence. They're getting it from a juror that reached out after seeing inaccurate reports in the media about the split. And there needs to be, one would think, more investigation before a judge can do it. There's Judge Ashley Wilcott. She knows what to do in a situation like this. First of all, Judge, your initial thoughts reading this motion. Wow. What should be done here?
Well, first of all, the right thing to do by the defense is to file a motion like this if they have information to believe it's true. But Ted, can I just tell you, the thing that bothered me the most at the end of this trial was nobody asked to poll the jury. This, from a judicial perspective, is why you have to ask to poll a jury, because if they'd done that, they would have known right then and there to figure out what to do next if, in fact, 12 said not guilty of the higher charge. So I don't know the law. I haven't yet had a chance to look at the state law and this state case law, but I would want to look at, if you don't poll the jury, do you waive any right to raise it down the road? You might. So there are a lot of legal issues. But again, all I can say is, why in the world would you not poll a jury to address this at the time it was happening?
And normally, when a jury comes back and they cannot come to a decision, a mistrial is declared. It's not, on the record in the courtroom polling. What'd you think? What'd you think? What'd you think? Because it's a mistrial. But to your point, typically, after the dust settles and both sides want to know what the split is, right? Especially the prosecution. Are you going to retry this case? Well, how about finding out what the split is? And it doesn't seem as though that was done. And now we're in a position where you have a juror contacting the defense saying, I was watching the TV and they had it wrong, or I was on social media. That wasn't the split. Jessica, again, do you have to do a full investigation before you can even think about another step? Because if this isn't accurate, well, then there is no next step. But if it is, boy, it's a head scratcher.
I mean, I think, to the judge's point and what you were saying a little bit earlier, to loop on that as well, one of the reasons you're polling the jury afterwards too, from being the advocate standpoint, is what are your arguments that landed well and where were there maybe missteps? So if you do have to retry this case, to improve, to tighten, all of those sorts of things, where the holes are, not to mention the situation that you're in now. So certainly, again, I have to go back to the foreman of whoever this is. We don't know. I haven't looked at the motion yet to see who it was. You can't make legal decisions based on what is complete hearsay and gossip, right? We know this in general. However, there are, and certainly, I think the judge will be aware, the larger argument here, I don't see a way that they would necessarily reach out to every single juror before they make a ruling on this motion to say whether that is true or false. The question would be, I think put to the foreman at first of, did this situation occur? Was there a vote on this count? And then it was unanimous. Was there a vote on this count? Where are the records of that? Where is everything of what, that they had as to what they actually voted on, and to how they interpreted and how the foreman interpreted the form at the time?
Judge Ashley, your thoughts on that and what you think should be done now at this point. And another question for you, isn't it up to the judge at the end of the day to have gotten this information to facilitate the conversation between the parties and the jurors after a mistrial was granted?
Yeah, well, I just wanted to comment on that. Ted, as the judge, honestly, you always have to look at the verdict form to make certain that it is correct in terms of how it's filled out. So arguably, this judge knew that it was 12-0. If in fact it was, we don't know confirmation of that. We just know that's what's in the motion that a juror has said. But the judge should have looked at the form of the verdict, and I guess I wonder, under the laws in that state, again, case specific, should the judge have said, all right, we've got a problem here because this is a not guilty. This is not a hung jury on these charges. So that's point one. Point two is, Ted, you're absolutely right. Two things. Number one, the jury could have been influenced by now because they've seen everything, heard everything. So how do you know when they come back and say, oh no, we all said not guilty? Has there been any bias? Has there been any changing of minds because of everything they've now heard? Number two, a judge can never make a decision without evidence on the record, period. Legal arguments, evidence on the record. So no matter what, if the judge is willing to consider this, my opinion is there has to be an evidentiary hearing.
Oh, yeah, for sure. And, I think they didn't fill out the form. I think they thought that if what is being alleged here by the defense in this motion is true, I think they got back there. They were going through it. All right, we all agree this is it. And then they're like, oh, gee, we can't get them all. This is a mistrial. We can't. There was a misunderstanding there if what they say is true. But that's the big one. If it is true, we'll have. So Judge Wilcott, if you were in this predicament now, do you bring all the parties in and, to Jessica's point, bring the jury foreperson in to get some clarity?
I think almost you have a hearing with attorneys only to determine, is there merit? Does it need to go forward? And then if you determine under the case law, under the legal arguments, that you then do need to have a hearing, which I would suggest she might, then you do bring in, you have to bring in evidence. So you're going to have to ask the jury. And the alternative, the first thing I would do as judge is go back and get those verdict forms. Right, Ted, to your point, let's see what they say. Was there a misstep by the judge if in fact it reflected that it was 12 to 0, 0 to 12, and therefore should have been an acquittal on those charges? A lot of homework this judge has now.
And if it's true, Jessica, if you're Karen Reed, hey, I'm crying foul. I mean, the jury voted 12-0 on the top two charges. Cut me a break. This would be double jeopardy if you try me again.
Yes, and we know this will go, directly to everything that the defense has been saying from the get-go, and that they said, as we know, because, I was on with you when we were going back, and the judge at first said the form is fine, then came back and changed the form. The jury was out. She had to go back, and she said no, after reviewing it, that she did feel that there were some typos and some various things that needed to be changed on it. So we know that there were issues around this from the very beginning, and clearly there may have been some issues. I think the judge and I both agree completely that I don't know in the state of Massachusetts if there is precedence for this as to what the steps should be next, but certainly this is a boon for the defense regardless of whatever happens next, because we know that whoever will be in the next jury pool for whatever happens going forward, everything around this, doubts are sown from the get-go now going forward.
Yeah, absolutely. In a case that was already a powder keg of emotions in this community, it's just going to explode now. The Free Karen Readers are going to be out in force if they do recharge or try to on the second-degree murder for sure. Again, the breaking news at this hour, Karen Reed's defense filing a motion saying they've heard from a juror that claims that they were in agreement on the top two charges. 12-0, not guilty, but it wasn't reflected in the mistrial because they came back to the court saying we couldn't come to a unanimous decision. Yet might they have already on those two charges? They should have written that down. Those were verdicts, if indeed all 12 agreed.